Okay, hi everybody. I think we'll go ahead and get started. I see some people trickling into the room. Thanks for joining us this morning. Talk about cannabis real estate considerations. My name is Cassia Furman. I'm a partner with Vicente in the firm's Los Angeles office. Work frequently with cannabis, both cannabis tenants and landlords, and I'm excited to share with you some of our experiences in the area and how we see this field evolving, and specifically highlighting with my partners, Sally Peebles from the Florida office on tenant considerations, and Eric Sauter in our New York office, also works in Connecticut, about real estate finance considerations as well, which is an area that we've been beefing up our practice in as these deals and the considerations around real estate get larger and larger as the industry accelerates. So for today's session, just to kind of walk us through the agenda, some lovely pictures of us. We're going to start with tenant considerations and really kind of looking at the landscape of emerging markets in the field and what's out there from real estate consideration in the expanding cannabis market with Sally. I talk a little bit about enterprise structuring techniques and strategies with Eric. I'm going to cover the flip side of tenant considerations, which is landlord considerations, but I think that really to have a successful landlord-tenant relationship in cannabis, there's a lot of intersecting interests between the tenant and the landlord. So I think the information in both sections will be helpful to both groups as well as prospective investors. And then Eric's going to fill out kind of the meat of the presentation and our focus today, which is real estate transaction financing and best practices. We're going to try to leave 10 minutes or so available for questions at the end, and encourage everybody who doesn't get a chance to ask the question to follow up with us with an email, and also check out our resources on VS website. So with that, I'm going to turn it over to Sally Peebles. Hi, Sally. Tell us about the cannabis tenant in 2021.
Hey guys, yes, this is Sally Peebles. I practiced out in Colorado for a bit, and now I'm running our Florida office. So I've really seen a very interesting way that the cannabis industry has evolved over the last 7 years. And as the industry has evolved, so has that landlord-tenant relationship. So back in Colorado, back in 2014, when I started, the landlord was super hesitant to enter what they saw as a very high-risk contract. There were a lot of unknowns surrounding forfeiture risk. Tenants were primarily having to pay in bags of cash. The stigma around the new industry was just really generally made landlords wary. In this situation where the landlords were not willing to work with cannabis tenants, and you add that into an environment like Colorado and Oregon with hundreds of licensees competing for these limited spaces, you ended up with the landlords definitely sitting in the catbird seat. They had all the bargaining power. And now if we flash forward to 2021, as the industry has crept across the US and is booming, renting to a cannabis tenant is certainly less novel now. It's seen as a bit less risky. And we also have years of market data for a landlord to look at and realize that they can do extremely well by renting to cannabis tenants. And then you add that to a state like Florida or any of the limited market states in the East Coast where competitive licensing reigns. And you're going to see that flip side of the earlier situation where we have landlords actually competing for licensees. This was very shocking for me moving from Colorado to Florida. In Florida, all of a sudden, my clients had much more bargaining power. They had much more reasonable rental rates. Where in Colorado, a personal guarantee was a must. In Florida, definitely had the ability to negotiate limited guarantees or corporate guarantees. And then even, to take it more extreme, if you could look at a state like Georgia that only had 6 licenses in the whole state, we even saw landlords lobbying their local jurisdictions to offer incentives to these licensees so that they could locate their businesses there to bring jobs and economic growth. So much more embracing nowadays. It's just very interesting to see how things have developed over the years. So, for real estate location and zoning challenges, we really have about three main challenges. First of all, one of the policy decisions that every state has to make at the very beginning when they're regulating these programs is, are we going to let the local jurisdictions ban? Now, they usually do that to try to get votes, especially with initiatives, because if the local jurisdictions or the voters think that they're going to have some control over where these businesses are going to be located, they're more apt to vote it in. So unfortunately, some local jurisdictions, some states allow that, then the local jurisdictions end up banning. Then they wait and see, okay, wait, the sky hasn't fallen. Then we'll change the ordinance and allow businesses to come in. So we definitely saw that in California, where 2/3 of California cities or municipalities prohibited adult use marijuana businesses, even though it was legal at the state level. We also saw that in Florida. Florida said, hey, you can ban, but if you decide to let them in, you can only place them in a pharmacy zone. So that brings us to the next point. Zoning restrictions. Generally, you're going to see these types of businesses restricted to certain zones that are for their intended use. The example, infused products might be in a light manufacturing zone. And like I said, Florida, a dispensary is going to have to be in a pharmacy zone. And then the third one is really the sensitive use setbacks. So when you're looking at these new states, this is going to be number one step in due diligence, like how far away are we from this sensitive use? Another thing that we see vast differences is in different states. In California, all marijuana licensees of all types have to be 600 feet from schools. And you see this a lot. Most states, legislators don't want these businesses near where a child would be playing. And in New York, they have different setbacks at the state level for different uses. So retail licensing and consumption licenses must be 500 feet from schools and 200 feet from worship. Now in Georgia, again, another extreme example, we're in the Bible Belt here, and all licensees there would have to be 3,000 feet from schools or churches. So the wide range of differences. And then you do want to make note when you're entering these new markets, just because you're looking at the state setback, often the local jurisdictions are allowed to even create more stringent setbacks. So I did want to just touch on a few cannabis-specific lease terms. The first one is, cannabis companies don't really have access to traditional bank lending. So they often have to bring on private capital, which means they're often going to be in a position to have to bring on new partners. So in light of that, you want to make sure that the tenant always has the ability to assign ownership to new owners, and that the landlord doesn't have a right to terminate if, say, 50% of that entity's ownership changes. And that's a pretty common clause you'll see in leases, because the landlord doesn't want to end up contracting with a party they're not familiar with or they haven't vetted. So it's a careful dance to play with that, but just something to keep in mind, especially when you're thinking ahead to your exit strategy as a tenant. Secondly, guarantees. You got to anticipate a landlord is definitely going to ask for a guarantee, especially in these competitive states. However, like I said, in Florida, things have shifted a bit with the tenant having more bargaining power. They can often get away with, liability cap, and they can include a burn-off provision saying, hey, the tenant's been maintaining compliance with the lease, paid rent on time over a long period of time. So let's let that guarantee burn off over time. And then finally, control. You want to ensure that the tenant has control. This is primarily because it's a regulatory provision, and regulators want to make sure that the tenant that has been background checked, that they're comfortable with, that has been vetted, are the ones that are actually operating the license that they issued. However, making sure the tenant has control is not just a tenant consideration. It's also beneficial for the landlord, because to lower their liability, they want to make sure there's no appearance that the landlord's operating a federally illegal business. So great to have that for both parties. And then finally, this is kind of Cannabis Lease 101, but I think it bears repeating. We want to make sure that you carve out compliance with federal laws. Otherwise, the tenant can be in breach of contract on day one of signing that contract or the day one of starting operations. On the flip side, you want to make sure that you're in compliance with only state and local laws. And then the last one consider arbitration for privacy purposes. Now, marijuana still has some stigma, and you want to ensure that we're keeping this away from a jury. So you may want to consider arbitration for privacy purposes. And along those same lines, it's important that the state law that governs the contract is one that expressly provides that cannabis contracts are enforceable. And it helps the party to avoid the other party arguing that the contract is void or not enforceable due to the illegality defense. And here is that compliance with laws that I touched on earlier. You want to make sure that you're carve-out compliance with certain federal laws, that you're ensuring compliance with state and local regulatory laws, and finally, that the lease, it clearly states that what you want to do, you can do on that lease. So you want to make sure that the permitted use is very specific. And what we're seeing in some of the newer states, a lot of these leases say, okay, they can operate a medical marijuana dispensary, for example. But in Florida, we are anticipating hopeful adult use change. So you want to go ahead and anticipate that and draft that clause broad enough that the use is no longer going to be compliant if the law changes in the future. All right, with that, I'm going to kick it over to Eric to discuss enterprise structuring.
Hi, thanks so much for the introduction, Sally. To reintroduce myself, I'm Eric Sauter. I'm a partner with the firm's corporate practice group. I'm based out of New York. I joined the firm in June of this year to help our firm co-lead its debt finance practice group. As Cassia said in her initial introductions, there's a lot of excitement, particularly in the tri-state area where I'm from, New York, Connecticut, New Jersey, with cannabis as deregulation rolls out, and folks get interested and excited about entering into our region. I come to the firm with 10 years experience, primarily in the field of commercial real estate finance and business finance. I help lenders and businesses across the country access capital for capital expenses, operating expenses, and accessing real estate. And I leverage that experience for our clients at Vicente Cedarburg so that they can have fair and market rates on their and market negotiation of their loan products. With that in mind, I want to touch a little bit on enterprise structuring. I think it's very important for operators, for businesses in the cannabis space to realize they aren't just purveyors of marijuana. There are lots of things. They wear lots of different hats. One thing that you might be is an operator, but you also could be a property owner. You also might own intellectual property. You also might be a licensor. You have a lot of different things, a lot of different assets. And something that's important to think about is properly structuring your enterprise for those interests that you have. Primarily because with respect to your operations as a cannabis operator, you're going to have to deal with 280E of the IRS code. 280E of the IRS code is an important element of operations for a cannabis company. It doesn't allow you to take any deductions when you're doing your taxes every year, and incurs significant cost to the operator. That's not similar to traditional businesses. Traditional businesses can take deductions. They can make their cash flows a little bit more consistent and expected. With operators in the cannabis industry, it's a little bit different. It gets kind of hairy, and that's why you want to think about enterprising out and setting up different entities so that you can have more traditional access to taking deductions for of your business. In the commercial real estate context, it's also important to consider enterprise formation because lenders traditionally like to see your property held in what's called a special purpose vehicle, a special purpose entity. And they do that for several reasons. One, primarily, they want to make sure your asset is held by one company in its own name. It doesn't operate any other asset or business model, so that it can be foreclosed upon. You want to create a bankruptcy remote entity, a dissolution averse entity. So you'll see a lot of lenders requiring the formation of a company that satisfies those two goals. Primarily corporations, Delaware limited liability companies are popular for holding real estate. Delaware LLCs and in Delaware code, particularly important and popular, because in Delaware you can waive your fiduciary rights as a manager to vote for bankruptcy. Obviously in cannabis right now, bankruptcy is not something that operators themselves are privy to, but property companies may be. So lenders still want to see that your property is held in a bankruptcy remote entity, and also one that won't suffer dissolution if a manager or a member withdraws from that entity. So LLCs are very significant and important in that facet. So I just wanted to kind of touch on those things, kind of put the earworm and the light bulb over folks' head to start thinking about how they want to structure their entities as they start pursuing licenses, because it is important to make sure that your enterprise is properly set up. And with that, I'll turn the dais over to my partner, Cassia, to talk about landlord considerations.
Thanks, Eric. That's a great segue. Part of the enterprise structuring and the discussion about landlords is also that traditionally, I think we still see that this is a dynamic, owning real estate and then leasing to a cannabis tenant, which is very ancillary and not plant touching activity, avoids 280E. It avoids some of the stigma of operating a cannabis business yourself. It's perceived as allowing a different way of working with the business and perhaps obtaining some of the high yield benefits that go along with the business, that sort of high risk, high yield opportunity that is still safely removed from a plant touching activity, which is just deemed to be very high risk by some companies. I'm going to talk a little bit about from the landlord perspective, opportunities, challenges, and then risk mitigation. Work with a lot of landlords in the space, as well as investors and many operators as well. And risk mitigation is always what people want to know. I mean, I can provide a long memo on what federal illegality means for all the parties involved, and everybody says, thanks for the beautiful memo. What can I do to mitigate the risk? And while cannabis remains as Schedule I controlled substance at the federal level, that risk for the operator entity at least can't really be mitigated down to zero. And there's some particular perhaps unique risks involved for the landlord as well. We mentioned asset forfeiture, which is a whole other topic we could spend a lot of time discussing. Outside of this context, is a traditional risk, which is in states like California now mitigated quite a bit by state laws, but we still see some seizures happening. I think there was recently a situation in Kansas that came to light, so it's not completely off the table. But just to provide a high-level overview of opportunities and challenges for a prospective landlord in the space. I mean, the big one has been the opportunity for increased revenue from above market rents. Early on in Colorado, we saw, really a distressed class of industrial and commercial buildings being taken over for cannabis uses, and actually increasing the value of some of those portfolios for investors and owners in that space. And even outside of a sort of distressed or semi-distressed area, like in California, for example, where real estate always seems to be booming, at least in recent years, there's still an opportunity to charge above what we consider to be above market rents for cannabis tenants, just given the high risks involved for the landlord. There's often also a requirement placed on cannabis tenants and operators that they bring the building and all of the activities therein up to code. which is, typically not required for a new use as long as it's within, by local zoning codes, as long as it's within the purview of the types of buckets of activities that have been traditionally permitted in that location. For cannabis, all bets are off. If it's, a manufacturing facility that's now going to be cannabis manufacturing, all of a sudden, typically the building will be required to be brought up to code. So it's a potential for a landlord to finance improvements to the building with the tenant. And the businesses also require very specific security infrastructure, which, I think some of these items can go on an opportunity, but also on a challenge or a potential risk for the landlord, because there are a lot of challenges in running to a cannabis tenant as well. We mentioned the lending, and that also impacts the number of landlords that can realistically rent to cannabis tenants. What we've seen in states where there has been longstanding cannabis activity in leasing is that, at least in the early days, landlords didn't always recognize that if they have commercial paper on the property and the refi rolls around every 5 years or so, the rent roll showing a cannabis tenant is going to be a huge problem for a conventional lender. So, really those properties are largely, inappropriate, at least under current laws, for a cannabis tenant. Touched also on access to bankruptcy courts being limited. Now, there may be access to state bankruptcy court in some areas, and there's also, for example, in California, successful receiverships and sort of ABC actions, assignment for benefit of creditors, some alternative remedies for landlords in the events of a default. And there is a high level of risk associated with the lack of finance and capital within the conventional markets being available to cannabis tenants. They tend to be a fairly unstable class of operators, and there's a lot of activity and ownership changes that come and go from the industry, and that impacts stability for the landlord. The businesses are also, even though in a place where we are in 2021, where I would say most cannabis businesses in state legal markets have access to some form of banking, and not all of their transactions are in cash at this point, it's still traditionally a cash-intense industry. And unfortunately, some of these facilities, both with the value of potential cash on hand, but also the value of the products and the plants themselves, if sold out of the legal markets and in the illicit or private markets, they can be a target for theft. We don't think overall that it increases the overall crime of the area based on statistics that we reviewed, but on an individual basis, there's a reason why the security requirements tend to be more. And then another topic I'll cover a little bit is disclosure as a regulatory owner for the landlord to consider, depending on how closely associated they want to be with the cannabis industry. For example, a profit sharing mechanism between the landlord or potentially control, though we don't really see that being implicated as much, could subject the landlord entity to disclosure on the cannabis licenses, which isn't necessarily, a deal breaker. But if you have investors on your cap table from the real estate side that are uncomfortable with cannabis, that's a big consideration you should think about before getting involved. Just a couple practice pointers here for potential investors and landlords in this space. These are some of the first things I talk with when people approach me and say, we're interested in the space, we're interested in either providing capital or perhaps acquiring a building ourselves or putting an existing building to cannabis use. Understanding the local cannabis landscape is huge. And I included cross-referencing sources because at least here in California, I found that the general state of things is people tend to say whatever about the viability of the business and the suitability of the location. There's a lot of eager brokers out there and people who are very motivated to find property. And there are often some sneaky restrictions in local zoning codes. Sally mentioned the high degree of local control over the cannabis industry, and that's certainly prevalent here and in other states. making sure you understand if your facility is going to be viable, and it doesn't just end with whether it's in the green zone, which is what we often call the zoning that's appropriate for cannabis activity in a particular municipality or county, but also extending beyond to the setbacks that Sally mentioned. And also a big sneaker is often an actual setback from another cannabis facility. So a lot of localities will have an express restriction on their book saying if you have a dispensary operation down the street, then it's not viable to locate another one within 1,000 feet. And if that's your plan to make use of your property, then you need to know what's going on around you, whether there's changes on the council, political landscape. This stuff moves very quickly. So being informed and cross-referencing what you're hearing from a prospective tenant or a broker is important. Focus on fundamentals, don't need to go into that. Always use a term sheet, another common sense item, but have seen many deals both on leases and sort of supply chain arrangements where the parties will spend 1,000 hours going back and forth on an agreement when they could have, started with a pretty simple LOI or a term sheet and saved themselves a lot of time if they weren't going to be able to meet, in the middle. Eric already talked about use of an SPV. I'm going to talk a little bit more about, both vetting the property and vetting the tenant from the landlord side, and that's a big one too. So navigating the legal landscape, this is largely related to disclosure again, and what that means can vary from a state to state basis and even at a local government. In 2021, the perception of fears associated with, having your name associated with a cannabis license, even if you're not, a responsible party for that license, is less than it was 5 years ago, certainly, but still prevalent in some areas. And there may be secondary considerations present where you just don't want to have to disclose your name as a landlord party if the state requires that disclosure, if you have a profit sharing interest, etc. So typically when we work with landlords on deals, we'll try to identify those issues early on and work with them then to structure an economic arrangement with the tenant that will either avoid the disclosure if they, have sensitivity in that area, or potentially, go from make sure that you're not being disclosed at one level and a lower one. Just a couple other items. Sometimes you'll be required to submit affidavits. Almost always a lease is required to be disclosed to regulators, both at the local and the state level. Property liens are occasionally vetted, along with sometimes even the amount of rent. So if you're not a person that isn't comfortable with some level of unusual for the real estate context disclosures, then best to consider participation in this industry. And although we do expect federal legalization remains on the horizon, I don't expect that this will materially change. I mean, if you look at sort of analogous industries to some extent, like gaming, etc., this is fairly common, even when there is some level of legality at the federal level. Talked a little bit about profit sharing. Many states state that the right to receive a portion of revenue is considered either beneficial ownership, which is a Colorado term, or some level of financial interest, which is a term used in California. And in other states, the thresholds for where those disclosures are made and what that means for the landlord varies quite a bit, again, from state to state. So just be aware of where you're at and what your comfort level is and whether it's a consideration. If you don't want to go through a background check and it's not a good idea, then you should structure the relationship differently. Just a couple background slides here on some of the various state definitions. I'm not going to dwell on those. There's a lot of different terms for the same thing, which is basically disclosure as a financial interest holder in a cannabis license. Again, not all landlords are going to have to be disclosed. If you just have the conventional lease terms with no back-end profit sharing or special financing with, controls over the company, you're not going to have to worry about this, but it's just something to consider. In terms of risk mitigation, to sort of wrap my section up before I pass the mic back over to Eric, it's both in vetting the property and vetting the tenant. Vetting the property, we talked a little bit about site-specific characteristics and setbacks from other cannabis uses, which is very sneaky and sometimes difficult to even check, because if there's applications that are pending in a hot new area for licensing, it's difficult to get that information. And so a lot of times these processes are somewhat iterative, and also more information is revealed as the process unwinds, and there can be changes in local regulations and stops and starts to licensing that are all impactful to landlords. And so, related to that, the pro forma, you need to be realistic about how long it might take for these facilities to open. It's almost always longer than everyone thinks it's reasonably going to be at the start of the process. Typically, there's both a local permitting process that involves some sort of land use plus consideration, and then it's always heightened for cannabis, and then also a state application process. And you have states like New York and New Jersey that everybody is really excited about, and we're getting calls from landlords and tenants in our New York office all the time. And finally New Jersey is moving forward, but New York is still, it's probably not going to be, I think they've announced until 2023. I might be misstating that, but likely when activities commence. So, there's both delays in regulatory permitting, and then just getting the materials reviewed when you do submit. It increases the risk of default and the carrying costs for these tenants. And so you'll often see a lot of back and forth between tenants wanting an out of the lease clause if they're not able to be licensed, or lesser rent until such time as they are licensed. And those are, good negotiating points to go back and forth with, to make sure that as a landlord, you're able to realize your investment, and as a tenant, you're able to open. But it's very difficult to predict the timing in a lot of cases. Also, looking at the property, Sally touched on this a little bit. There's a lot of locations that have limited licensing. The political structure changes significantly, and political landscape. Whether a certain council is favorable to cannabis zoning in your area could change within the time that you are, considering going forward with this activity. Usually it gets better, but in the cases of cultivation and some cases in California, we've actually seen it pulled back and more restrictions put in place. So, and the other item I tell landlords to look at is what your local taxes are, because if you're in an area that has, pretty available real estate in different areas, the tenants are always going to look to what my local taxes are. And if it's a small enough jurisdiction, it's something that you may even be able to impact as a prospective landlord. And we have seen a lot of folks on the real estate side get involved early on with vetting and talking with the local governments about making things a little bit more favorable to tenants and hence to landlords as well. Also looking at market trends and seeing, related to the pro forma, what's going to be realistic. On tenant diligence and vetting, I'm going to cover these real quickly. Just understanding some of the basic considerations in cannabis. Making sure that you have an ongoing requirement for compliance, and then reporting if there are issues on their license, so you can keep track of how they're doing. It's a difficult industry to operate in from a compliance perspective as well. Some states have almost no enforcement on their compliance, and some states are extremely diligent on compliance. So good to understand that landscape as well. Tenant improvements we covered, and then also understanding that insurance is going to be difficult to obtain. Going to cover this at a very high level as well, use specific clauses, just understanding what some of those cannabis specific uses are, and looking at some perhaps specific considerations around their use of the property, which really shouldn't be too different than for other similar non-cannabis uses. And with that, I'm going to turn it back over to Eric to talk a little bit about best practices for transactions and real estate financing.
Thank you so much, Cassia. And I think it's a really good segue from your discussion in terms of talking about timing and also the property or the locality by locality specifics that might be your gating issues related to whether or not you're ready to accept debt for your business, for your real estate, and also some of the timing concerns that maybe give you some time to plan for accepting that debt and getting yourself ready to acquire real estate or use your real estate, accept a loan for maybe some expansion work, construction work at your facility, and then negotiate with a potential tenant to come into your property. So with that, I'm also going to take my own advice and think about my timing. I do want to cover a lot in a little bit of time, so I'm just going to touch on some of these things and maybe leave it open to questions at the end. But there's some, I think I put together 5 key takeaways that I just wanted to go over on this talk. The first one is really the gating issue of what to expect when you're looking for debt. There probably will be disclosure requirements with respect to the loan. Your lender itself will probably have some disclosure requirements itself, maybe providing its background information, making some background disclosures to the regulators with respect to providing capital to a business operation operating in cannabis. So those are some things to think about up front. Second thing I want to talk about quickly is activity in the debt market. Who's lending and what are the typical debt structures? Expansion loans, sale leasebacks, construction, debt available for construction and improving your real estate, things like that, business lines of credit. Fourth, I would like to talk about some things, maybe just dispel some common myths that are prevalent in the industry relative to accessing capital for cannabis operations and cannabis real estate, as well as negotiating the loan documents themselves. Fourth is really just preparation. I want to bang away at the concept of preparing. There's no alternative for good preparation, and preparing for the term sheet, preparing for the legal checklist is going to put you in good shape, in the best possible shape with respect to accessing debt capital for your cannabis operations, for your cannabis properties. And then finally, the industry plagues that you can expect when you're marching towards closing potentially on a debt transaction vis-a-vis cannabis real estate. Banking, insurance, bankruptcy certainly are going to be hindrances on the march towards closing, but I don't want anybody who's listening in to think that they're an absolute wall and barrier to accessing debt. And there are some ways that we can address those issues, hopefully in the context of a lender-borrower relationship. So the first slide that I have up is really that gating issue on the regulatory challenges with respect to lending to cannabis businesses. What are the requirements of a lender? What are the requirements for accessing your loan from a provider of debt? Pre-approval may be required depending on whether and where the lender itself had held licenses before. They also may need to provide some information on their backgrounds to the regulators. In some states, loans themselves must be disclosed when a cannabis business undergoes its annual license renewal. So those are some things just to keep in the back of your mind when you're at the interest phase of accessing debt for your operations for your cannabis properties, is what those disclosures might entail. If you're a lender that's interested in making money available to a cannabis operation, what are those disclosures going to be? Again, it's case by case, not case by case, but locality by locality and state by state specific. So the important thing to remember is just having good counsel who can navigate that with you and let you, advise you so as not to trip up on any of those regulatory requirements with respect to disclosures. This slide really just kind of talks about background checks again at a high level. It varies state by state. So it's something that you just want to consider from the lender and borrower relationship perspective, whose information is going to need to be disclosed to the regulators, what needs to be disclosed in terms of the licensure, not to trip up any licensing requirements. Lenders should be prepared to disclose the names of their stakeholders as well as their management teams in any event, just so that you're ahead of the curve. But certainly work with your local attorneys, with your attorneys that have that can meaningfully advise you through that process of disclosure. Regulatory challenges with lending to cannabis business in general. Now you're at the phase where you're negotiating loan documents, maybe you're negotiating your term sheet. Lenders are most often not just going to take a secured interest in your real estate, but they're going to have something that's a little bit more enveloping over collateral classes as a whole, a mortgage and security agreement, ancillary security instruments, account control agreements, pledge and security agreements. Well, what does that mean to you as the borrower, to you as a lender? Again, because of the state by state and locality by locality rules that govern what you can collateralize and when, you just want to make sure that you're mindful of your collateral as you're negotiating those documents. As a quick, for example, context is key. Some states don't contain explicit restrictions on collateral, others do. One state's collateral's regulations might not include any particular restrictions on collateralization, but it might prohibit a cannabis license from being transferred as an asset. So know if you're getting into a present assignment of collateral, it might not be something that you can do in that particular jurisdiction. Again, perhaps the regulations permit a collateral interest on licensure, at least at the security agreement phase, that it might not trip up regulations to execute a security interest. But certainly upon transfer, the regulators would want to get involved. So possibly in states that permit it, you might want to partner or have the ability to appoint a designee or a receiver that can hold that license until such time as the lender can find a licensee that they can transfer it to make themselves whole on their loan. Affirmative and negative covenants. Now these are the provisions of your loan documents themselves that say predominantly I shall and I shall not. The things that your lender is going to say to you, these are the no-nos, these are the things that we want to make sure that you're doing and you're actively pursuing, actually complying with as your loan term continues through its maturity. The problem with these covenants, these affirmative and negative covenants, is that they create a specter of control. And if there's a specter of control in your loan documents, again, the regulators kind of catch a whiff of that. And they may, consider you a controlling party, somebody whose name might need to appear on licensure. And again, it's triggering potential regulatory issues because of the state by state, the locality by locality specifics of dealing with debt. It's very important to work with counsel that understands what those local rules and regulations are, and what you can and cannot do in terms of being a lender and what you can control. My next slide is actually going to discuss a few particular loan documents where the specter of control has kind of come up in the past. Management agreements. Some lenders like to take assignment in subordination of management agreements. And if you take assignment of a management agreement and you rest control over the ability of an operator or over the ability of a property company to manage cash flows, probably could raise the specter of control, and you have to be careful negotiating in instruments like that. Guarantees as well. Guarantees are documents where a person who is responsible for the debts of dispensing, or possibly of a dispensing organization, may be considered a principal officer of that organization, subject to background checks and disclosures. So it's best to confer with counsel before you have a guarantor execute a guarantee. Interest rate seems benign, right? It's a key concept of any loan document. Note. But in some jurisdictions and under certain cannabis laws and regulations, a financing agreement must have a reasonable interest rate in order for the lender to not be considered an applicant itself. So if you're negotiating in a jurisdiction that has such context over interest rates, it might be a good idea to include a reformation provision in that loan instrument, which allows for the interest rate to be lowered in the event that the regulators find such interest rate to be unreasonable. Not to trip up that type of regulation. Touching on debt activity. So who's lending money in the industry? Predominantly, you can probably go, look around. You can go online and find accesses to capital. But I'll go over a few here. Cannabis REITs. These are real estate investment trusts. They tend to be the most sophisticated in the field because kind of REITs in general. They're private sources of equity. These are wealthy investors who have an appetite for lending in the cannabis field. They have an appetite for that industry. They understand the risks. They understand the local regulations. So when you're borrowing money from a REIT, you'll probably find that there's a level of sophistication there that is helpful, honestly, to you as the operator, you as the propco for accessing capital. They usually have a good degree of transactional competency. In their documentation, we've seen lending rates, interest rates as high as around 14%, but I've also seen them come down into the 8s, and they generally have a term of up to 3 years when you're borrowing money from a cannabis REIT. We also see regional banks, community banks active lending to property companies, probably banks that are not required to comply with FDIC insurance, but they do have an appetite for cannabis lending. When you're dealing with a regional bank, you may have to be a customer. You probably do have to be a customer with accounts at the bank. The traditional requirements for borrowing from a community bank. Similarly, their interest rates could be competitive with the real estate investment trusts, but it's good to pursue and see what's available in your local community. Ask the question. Call the bank and find out if they're lending. You might be surprised, and see what their offering looks like. And then finally, hard money lenders are traditionally considered lenders of last resort, but they really don't need to be. Everybody in the capital stack has their purpose. It's usually considered fast money, but yes, your terms are going to be a little bit less desirable or advantageous to you in terms of interest rate, usually higher interest rate, lower, shorter terms. And then some of the structures that you can expect. There's a revolving and non-revolving lines of credit for business expansion, development, OPEX and CAPEX. Certain lenders might get into participations. You may get a sum of money from a lender that they then participate out to other REITs and to other lenders. And then there's certainly ways to navigate that on behalf of the lenders. Also, when you're a borrower, what to expect. Will it be a collateral agent that I have to deal with who's going to let me know if there's an event of default under my loan, who's holding the collateral in those participations and syndications, right? So you just have to navigate that and find counsel that can help you navigate that landscape. There's a sale leaseback transaction, which is good for operators, folks that don't really want to be in the business of property ownership. I want to sell pot, so I don't really want to own my property, but I found this property and I can purchase it. Well, you sell it to a REIT, somebody who does have that experience in property ownership, property management, and you lease it back from them. What does it do? It gives you immediate access to capital for your operations, for your expansions, and you enter into a lease on terms similar to what Cassia was talking about during her conversation, and Sally as well. That's advantageous to you, so that you can continue operating your operations at that particular real estate. And then refi loans and things when you get into the structure that you need with a mortgage lender and ultimately need to refi your transactions, your debt. Having said that, some of the common myths: don't I have to own real estate free and clear to access debt for cannabis activity or rent to a cannabis tenant? Not necessarily. I don't want you to assume. So it's always good to take a look at your loan documents with a knowledgeable attorney. One of my bullets is wraparound mortgages. If there's anybody, listening in who's like, how dare this guy talk about wraparound mortgages? They're anathema. Traditionally, they are, and probably if you came to me with a transaction, let me look at your loan documents, I might not recommend a wraparound mortgage, because basically what it is you have a senior lender, a mortgage in front of you, who has due on encumbrance clauses and due on sale clauses in their mortgage that would be immediately triggered if you recorded a subordinate mortgage. And that's exactly what a wraparound mortgage is. But maybe that mortgagee in their loan documents permits subordinate financing. Maybe, just maybe, that existing mortgagee recognizes what your interest and intent is for your property and would be willing to have a subordinate mortgage behind you, and has maybe provided you notice that they would not default you on your existing mortgage if you wrapped it. What does this do? It permits a seller possibly to sell their property to a buyer who can then purchase it from them with a wrap mortgage. It wraps the existing mortgage and it gives that buyer access to the building for their own operations and possibly gives the seller a nice advantageous interest rate. The buyer of that property probably couldn't access capital from traditional lending sources, so it gives the parties a little bit of a construct and flexibility. To do that, the seller gets the advantage of being able to have a mortgage directly with their buyer at a rate that might be higher than the existing mortgage, and then gives you a little bit of flexibility. But again, very important to look at your existing loan documents to see if it would even work. And then second myth, if they can't foreclose on my assets anyway, why should I pay attention to the docs? I hope that in the context of this conversation, we've already kind of taken, dispelled this myth. Lenders are getting much more sophisticated in terms of what they know can be collateralized, how to collateralize different assets than maybe in years past. Having a loan document suite that collateralizes everything is no longer just let go in that form. They're negotiated. It's structured in a way that the lender will have certain enforceable rights. And certainly, even if there are terms or even if there are collateral that can be severed from those security instruments, there should probably be left a good chunk of collateral that your lender can certainly foreclose against. So it's always good to take a look at your loan documents and make sure that you're negotiating them properly and paying attention to those state-specific rules on collateralization, so you don't trip anything up if you're the lender, and also if you're the borrower, making sure that you're not tripping up any regulations yourself by permitting a security interest in those collateral classes. That gets us to the planning phase of my talk, and I know that I'm running out of time here. I just want to touch on some of these issues. When you get into the term sheet phase, planning for that term sheet and getting into the nitty-gritty. Just touching on a few of these things that good preparation will help you along in. Certainly facility amount, how much are you looking to borrow, know exactly what your needs are. Interest rate and fees, I talked about before. Certain states say that interest rate has to be reasonable. You don't want to trip up your regs there. Make sure you negotiate your interest rates and that in mind, but also to make sure that it's advantageous to you. Prepayment strategy, that's your exit strategy, really. So if you have a loan, is it freely prepayable? You want it to be, but maybe there's an exit fee. Maybe you have to pay a portion of interest that your lender absolutely wants, but at least give yourself an out so that if you have access to capital down the line, you can close out your debt or possibly refi into something that makes more sense to you. The security that you have to give up, we talked about it. We talked about in terms of the state-by-state specifics, what you can collateralize and what you can't. Very important to negotiate that at the term sheet phase so that you're clear. We also talked about guarantors a bit. The conditions precedent, now this is interesting because typically lenders are going to require some due diligence on your property before they make you a loan. They're going to appraise your property. They're going to do an environmental site assessment and run a property condition report. They're going to use these third-party reports to inform them on whether or not the property is good asset, good collateral for a loan. One of these in particular I want to touch on, which is the environmental site assessment, because it also kind of goes hand in hand with what a tenant should be looking at when they're looking at real estate. For example, if you're a cultivator and you're interested in real property, when you run that environmental site assessment, you should be looking out for some key issues. Is there a history of environmental hazardous emissions? Has it ever been used, or is it adjacent to a parcel of property that has been used for uses that could have emissions, that could have releases of hazardous contaminants? Things like gas stations, like dry cleaners, traditionally are the ones that lenders take a hard look at. That could affect the groundwater supply, the potability of the water underneath the property. Very important to conduct your due diligence and at least look 25 years back at the environmental condition of your property. At Vicente Cedarburg, we have a very strong ESG practice that looks at environmental sites that can walk you either as a tenant, as a landowner, or as a lender through that phase of checking, of looking at your environmental sites and making sure that your asset is a good asset for your use. Title and survey, insurance and banking, these are the industry plagues I'm going to talk about in my next slide. But suffice it to say that a lender will probably require a loan policy of insurance, and will want to see the scope of your property on a survey, and make sure that there are no easements and things running through it that affect your property in an adverse way, or if there is, that there's recorded documents that deal with that. If you are a cannabis operator, you probably want to see certain easements that are beneficial to you. Easements for sewerage if you're a cultivator, or easements for water if you're a cultivator rather. Make sure that you have a water supply. Make sure you have certain things that you need, and that your property isn't landlocked from access to certain of your required utilities. So you're going to want to see that on your survey. We talked about covenants. We talked about some of those affirmative and negatives. Financial covenants and reporting, you can certainly negotiate them at that term sheet phase. How often do you need to provide your financial data and your documentation and things like that? Satisfying a legal checklist. Let me just see how much time and what else I need to talk about. So I'm going to talk about a few of these things. We talked about organizational documents up front, right? Which is your enterprise, operations, how you structure your companies. As you get into the checklist phase, you're going to want to be thinking about making sure your lender has access to your operating agreement, your bylaws, your certificate of formation, that you're an entity in good standing. Your lender's going to want to look at those things. Draft up good resolutions for entry into the loan. Your lender's going to want to see that. Space leases, reviewing the leases in much the same way as a landlord wants to negotiate them. The lender is going to pay careful attention to that. Make sure that your lease is good. And that your tenant has a good culture of compliance, and that your landlord, that their borrower, has good access to what they need to make sure that the tenant is compliant with everything that they need to be compliant with, to make sure that your cash flows remain strong during your lease term. Estoppel letters and SNDAs, I do want to touch on that because lenders require them from the tenant. It's a subordination, non-disturbance, and a torment agreement. Why is that important? Well, that's actually very important from the tenant's perspective, right? Because if they're going to agree to subordinate themselves and their interest to a mortgage, that mortgagee better in the subordination agreement acknowledge their use. I wouldn't want a tenant to subordinate its rights to a mortgagee who can foreclose on the property and kick them out because their use is considered technically or federally illegal. So make sure you review those documents carefully. And well when you're negotiating them. And the rest we kind of touched on. Ground leases are important if you're expecting to construct improvements on real estate. Maybe you're purchasing property or borrowing money to construct improvements on real estate. Reviewing your ground lease, making sure they're financeable is important. And existing mortgages to be assigned in certain jurisdictions that have mortgage taxes, like New York. Take an assignment of mortgage so you don't have to pay excessive mortgage taxes on it, and navigating that is also very important as you're reviewing your suite of loan documents. Which brings us to closing the loan and getting through that process. When and where, execution, and escrow. Finding a title company that can hold your money and ensure that you have somebody who can manage the cash flow at closing is important. Not all title companies do, so you want to find somebody who can do that for you. And how you're going to execute your documents. Certainly the documents that are going to be recorded have to be executed in wet ink, and you need to have a good set of escrow instructions for delivery of those wet ink signatures so they can be recorded with respect to mortgages and real property asset collateralization. And then finally, the cannabis plagues. Banking, it's difficult. It's difficult to access banking, to put your cash into, but not impossible. There are banks that are working with our cannabis clients, and we manage a list of relationships. So it's possible to find somebody who will work with the operators so that they have a place to put their money and make the payments in terms of a loan structure. So if your lender is requiring you to have a banking relationship, start investigating it and make sure you get out ahead of that. Insurance, difficult to obtain, not impossible. Certainly on the title insurance policy, title coverage often excludes forfeiture of your real estate. And it's something that just has to be negotiated in your title insurance package. So work with good counsel who can help you navigate that. And then bankruptcy, cannabis companies themselves cannot access federal courts. But like Cassie has said before, it doesn't necessarily foreclose you from the ability to have a channel, have a forum to dissolve and make your creditors potentially somewhat whole. State receivership, for example. So negotiate that in your loan documents. Your lender's going to want to see that if there's an event of default, there's a receivership right. They can choose a receiver, and the borrower maybe doesn't raise its hand and object to that. With that, and I think that I've really just run up against my time here. I'm going to open it up to questions, and if there's anything that my colleagues would like to add, I'm going to give them an opportunity to do so because I talked for a while.
Yeah, I think we've kind of run up against time. I didn't see any questions in the chat, but we did get a couple questions before the session. One of which that I can recall off the top of my head was essentially related to talking a local government entity into allowing cannabis use as their zoning. And I would say in terms of resources for that, we have VS Strategies, which is a policy branch, sort of offshoot of the firm that works closely with local and state regulators. So that's a great resource. I've personally also been involved in a lot of discussions in trying to convince local governments to, change a ban or license cannabis and get involved. And there's some good statistics from state legal markets like Colorado that have been around for a while. Some of the key items have been youth access and teen use, showing them statistics that they haven't increased. It's also around the actual property values, and there's some good statistics from Denver, especially since in Colorado, legalization occurred around the same time as we were coming out of the recession. And so it really actually increased the economic viability of some of the areas that were permitted for cannabis. So that's great. And I think in general, the trends are that cannabis, allowing cannabis uses from a zoning perspective tends to increase property value rather than decrease it, despite a lot of the sort of NIMBY complaints out there. And then just sort of understanding the zoning where it's going to make sense so that you can show that any public health and safety concerns are mitigated. So going in with a plan ahead of time is something that I recommend, that kind of hits on the points that local regulators tend to care about. Also want to direct folks' attention to, we have some other sessions, a session on REITs and some other real estate related content on the website. And if you do have questions to follow up from the session, don't hesitate to reach out to any of us. Our contact information is here. And want to thank everybody for participating. It's great to see some familiar and new names in the comment section. And it's an exciting landscape that we're all in this together, trying to increase opportunities. So thanks everybody, and have a great rest of your day.
Cheers. Thank you, Cassidy. Thank you everybody for joining.